This is Michael Popok, and it must be time for Legal AF After Dark. Just look at the glasses. Let's talk about Judge Aileen Cannon. Do we have to? Yes, we do. She just held a series of hearings and now has started to generate new orders that severely impact the prosecution's case and whether the case against Donald Trump in Mar-a-Lago is going to trial at all. You'll hear about what a Franks hearing is. What are we going to do with Evan Corcoran, who already had his attorney-client privilege stripped away from him by a judge sitting in the District of Columbia? Is Judge Cannon going to reevaluate it as she considers whether to suppress evidence in the Mar-a-Lago case against the prosecution? We break it all down for you, the only way we know how and the only place we do it. Legal AF on the MeidasTouch Network. Take a listen.
Let's talk briefly about what Judge Aileen Cannon did. Donald Trump was requesting what's called a Franks hearing, which is basically like a suppression of evidence hearing. And Trump claimed that the affidavit used in 2022 in August that was issued in connection with the search warrant that was executed at Mar-a-Lago had material omissions and intentionally material falsehoods that would require a hearing called a Franks hearing that could then result in the evidence obtained at Mar-a-Lago, the documents that Donald Trump stole, being suppressed. So that would basically lead to the dismissal of the case if you went through a Franks hearing and then all of the evidence, was suppressed as a result of the affidavit that was used to execute the search warrant. And Donald Trump claimed that the material omissions included just like a number of things that the FBI agent who filled it out didn't give a definition of personal records, or that the FBI agent didn't talk about how the FBI was consulting with NARA before the search warrant was executed, things that were actually not material at all. And look, to her credit, Judge Aileen Cannon said, I don't think that these are any types of like material omissions or material things that would change the general character of the affidavit and the search warrant that was executed. So the headline that came out was Judge Cannon denies Donald Trump's request to have this suppression hearing that was held. So that feels like a good headline. But you read deeper into it, Popok, and let me throw it to you. Judge Cannon's like, you know what, though? I think what I need to do independently is I need to look at what that well-respected, and she didn't say this, but she is a well-respected judge, not Cannon, but Judge Beryl Howell. I need to look at what Judge Beryl Howell did when she presided over the grand jury proceedings in Washington, D.C., in the grand jury that was used as part of the criminal investigative proceedings, because Judge Beryl Howell found that Donald Trump was using his lawyers in furtherance of crimes, and therefore found the crime fraud exception applied, such that attorney notes had to be handed over to special counsel Jack Smith. But Judge Cannon said, you know what? I'm not sure Judge Beryl Howell was right. I think it's my job, and this was her direct quote, to look anew at what Judge Beryl Howell did in finding the crime fraud exception applies. I want the parties to meet and confer and hold an evidentiary hearing on this matter. We'll do an evidentiary hearing, meet and confer about what the contours of this hearing looks like. So, Popok, we talked in the last episode about how Judge Cannon refused to listen to the chief judge in the Southern District of Florida Court, Altanaga, when she said you shouldn't even be taking this case. But so that was one way of just like giving the middle finger to your colleagues. But then here we have Judge Cannon also trying to usurp look, she is the trial court judge here, but this has been ruled on by another federal judge. And Judge Cannon's like, I'm going to look at it anew with fresh eyes, and we'll do a new hearing here. What do you make of that?
Well, this is probably my third time, including a hot take, telling you I've been very concerned about her going after the Evan Corcoran 50 pages of single-space notes testimony and his audio recordings about his representation of Donald Trump, which was the basis to pierce the attorney-client privilege by the chief judge at the time of the D.C. Circuit Court, Beryl Howell, after a full evidentiary hearing at that time, in which if they didn't like the results of it, I think that it was incumbent upon Donald Trump and his lawyers at the time, whoever they were, to take an appeal to the United States Supreme Court or to the D.C. Court of Appeal, and they didn't do that. I don't totally disagree with her. I'll be back into this part of this, my contribution here. I don't totally disagree that post-indictment and a suppression hearing prior to trial is the proper province of a trial judge, whether her name is Aileen Cannon or someone else that we admire, like Judge Altanaga. I get that part, but I don't get the process, as you so smartly noticed, is just built for the purposes of delay. She, like Judge Chutkan, could have ruled on this on the papers. She doesn't need a full-blown evidentiary hearing, not with the transcript that was already developed, which she's now asked for from this grand jury process presided over by a much smarter and wiser and more temperate judge than she, in Judge Beryl Howell, who's still on the bench, by the way. She just rotated off as chief judge. And now I get it. She wants to flex her muscle, and she chafes whenever she gets a whiff that she thinks she's being disrespected by the prosecutors. And it's happened over and over again. Karen and I talked about it on the midweek. I wanted Karen's view as a former prosecutor. I've done it as a defense lawyer, where I've gotten a little bit sideways with a trial judge or a magistrate, federal judge or a magistrate, and then the impact on that. It got so bad with David Harbach, who's one of the many prosecutors, lead prosecutors down in Mar-a-Lago, that the judge even said, if you can't be civil in my courtroom and answer my questions appropriately, then there are plenty of people on your team that can argue this motion. I mean, that's how bad it has gotten with this relationship, if you will, sandpapery as it is, between the special counsel's office and the judge. I mean, I've had plenty of judges where I've thought, I don't agree with this person. I think they're not properly prepared. They're not reading the case law right, and they're not following me. But you can't act like that. You can't act like the judge is not getting it. You have to find another way around the brick wall. So when I first read about the Franks decision, and then until I got to the second half of it, I was like, okay, well, this is sort of consistent with what I heard about the hearing, which is people forget this name because she doesn't really use him anymore. But Magistrate Judge Reinhardt, who sits in Fort Lauderdale, is her magistrate. And most judges who are more experienced than she would be using the magistrate for most of what we're watching her do if they had any intention to get this case prepared properly for trial in an expeditious fashion. But since Aileen Cannon doesn't, she's created a sandpit of her own making where everything has to go through her, with her multiple level self-created procedures of evidentiary hearings, and then those are weeks away, and then briefing schedules that are extended, and whenever Donald Trump sneezes or bats an eyelash, he gets an extension of that time, and that's all self-created. For those that are out there that are not yet on our Patreon or just wonder about the law, like, well, what is the timetable for the release of Supreme Court cases and how they drop? There is no. It is all created at the moment in real time by that current panel of the Supreme Court. There's no rules, there's no regulations, there's no you can file to make them go faster. And within a trial judge's discretion, yes, there are certain rules that say how many days for this and how many days for that. But in other places, whether it is going to be an evidentiary hearing granted or not, yes, there might be some precedent. We'll talk a lot about precedent with a C today. But it really is up to the judge to construct their own processes. We call them colloquially chamber rules. It's the rules of the chambers. I tell my lawyers who work with me, there's 3 or 4 things you have to know in every case, especially if you're the junior member of the team. One, if we're in federal court, the federal rules that apply, the local rules that apply, and the chamber rules that apply. What is the judge's, little peculiarities and peccadillos that you have to follow? You got to get that right also. And she just creates her own because she's never been on the bench that long. She's been on the bench a very short amount of time. So when I read the Franks decision, I was like, okay, she's siding with Magistrate Judge Reinhardt, who properly got that subpoena issued on the evidence provided and within the scope of the, scope looks right and the searching looks right. Okay, that's fine. And she doesn't find the grounds to overturn the actual search warrant issued by her magistrate judge, who, again, she should be using more as a laboring oar to kind of get through this case, but she does it for a reason. She wants everything with her. Second half of it is exactly what you and I've anticipated time and time again. It's the Evan Corcoran neon light. We knew when the attorney-client privilege got stripped from Donald Trump, because the client holds the privilege under the crime fraud exception, because Beryl Howell was the second federal judge, not the first, to find that it was more likely than not that Donald Trump, with a lawyer, committed a crime or fraud. Judge Carter, in where you practice a lot in Central District of California, in the John Eastman matter related to the Jan 6 committee 2.5 years ago, found that it was more likely than not, stripped Donald Trump from the attorney-client privilege and turned over all of that material through John Eastman to the Jan 6 committee. Same thing, Beryl Howell, on her own findings, based on testimony, including of Evan Corcoran, that we don't really have the transcript of yet, we have partially of it, and then decided that Evan Corcoran's interactions with Donald Trump were being used by Donald Trump to commit a crime or fraud on the Department of Justice and the United States. The way he handled or mishandled the classified documents. Evan Corcoran was not the first lawyer for the Mar-a-Lago matters for Donald Trump. He had an earlier one that dealt with the National Archive negotiations. That lawyer dropped out after Donald Trump refused to take his instruction or his advice. Then we had Tim Parlatore, Jim Trusty, and Evan Corcoran all there, all of which are now gone. And they were handling the day-to-day along with Christina Bobb and Jennifer Little out of Georgia. That group, and Evan Corcoran in particular, were responsible for interacting with the response to the subpoena. Let's not forget, and when I say let's not forget, I mean our audience, that before there was a search warrant in August of 2 years ago, there was a subpoena. Before there was a subpoena, there was a request by letter to turn over the documents that don't belong to you. That's all you had to do. And you can do it on your own if you do it right. But when the government figured out from insiders who were providing testimony and sworn testimony that supported the search warrant that Donald Trump wasn't doing that at all. He was hiding the 34 boxes. He was reviewing 70 boxes. He was staging the area for his lawyer to review after he had already sanitized the boxes and pulled out things he didn't want the lawyer to see. Because the lawyer, Evan Corcoran, gave him almost 2 weeks, turned his back on Donald Trump and let him do whatever he wanted. By the time he came back, they were like, oh, it's all in one room. Here you go. Here's the 30 boxes. And Evan Corcoran, I don't know if you remember this, Ben, testified along the way. He spent 20 minutes looking through 30 boxes, which is almost impossible. And he turned over those 36 or 38 documents, the now infamous folder with the tape around it. And he had Christina Bobb sign it and said, this is all we found. And that's all. But the interaction between Donald Trump and Evan Corcoran, which we already know about, was Donald Trump basically instructing Evan Corcoran to destroy evidence and to eliminate from his pile, pluck them out with a plucking sound, as Evan Corcoran put it. When he went back to his hotel at the Brazilian court around the corner from Mar-a-Lago. And Evan Corcoran didn't do that, but he did record that happened. And that helps with the mens rea, criminal intent, and willfulness component of the prosecutors. If they lose that, meaning there's a suppression of the Corcoran testimony, evidence, notes, and audio, prosecutors their case just got a lot harder. I'm not saying it's climbing Mount Everest without oxygen, but it got a lot harder. Now you're left with grainy videos of the two co-conspirators moving around boxes, testimony of people on the fringes around Donald Trump, but you had Donald Trump red-handed with mens rea through Evan Corcoran. It becomes a whole nother case and a whole harder case if the Evan Corcoran stuff is suppressed. So the first part, I was like, okay, that's what a normal judge should do. And the second part, I've been up at night ever since, not just because of my new baby.
Well, for the crime fraud exception to apply, there has to be two things. One, was a crime committed? And the standard for it doesn't have to be beyond a reasonable doubt at this stage. It just has to be, I think, by a preponderance. And then were the specific documents or communications with the attorney used in furtherance of the crime? So here, the reason why it's so odd she's like holding an evidentiary hearing is that it's kind of so obvious that the attorney-client privilege should be pierced. Often the hardest prong of that two-prong test is, for a judge to have to make a decision that a crime took place more probably than not. Like, that's really why you'd need to hold the evidentiary hearing in this area, because that's a big type of ruling to make. But then obviously here, especially as it relates to Corcoran, of course his communications here were then in furtherance, or Trump was communicating him in furtherance of the crime. We know what they were about. It was so that Corcoran could go in a different location while Donald Trump committed the crime and Walty now to move the boxes. So clearly it was in connection with prong one, the crime. And just so people know, again, that this is not how it's supposed to be done. Y'all remember federal judge David Carter in the Central District of California when he made the ruling with respect to John Eastman that the crime fraud exception did not apply, or that the crime fraud exception applied, that attorney-client privilege did not apply. It was handled, in a fairly concise order. There was information that was submitted. The judge read through the documents and was like, yeah, there's a crime, and these communications are in furtherance of a crime. And there were certain communications that had nothing to do with the underlying crime, and those would be attorney-client privilege. But as it related to the attempt to overthrow the government, Judge Carter was like, yeah, clearly that's in connection with the crime. These are fairly easy decisions to be made by a federal judge. But to your point, Michael Popok, Judge Cannon just keeps on delaying.
And just not to leave there is I am recognizing that there is a difference between Judge Carter's subpoena compliance hearing and a suppression hearing related to an indictment. I get the difference, but I totally agree with you. She does not have to create this Rube Goldberg contraption of weeks delay and evidentiary hearing. She could look at the grand jury testimony and hearing transcript, which the government will now provide her. And then with that and some briefing, that's it. She doesn't have to bring in live witnesses again. She says it's not going to be, don't worry, government. I know you're worried about a mini trial, but it's not going to be. And then she goes on in her order to describe effectively a mini trial that she's going to be conducting about this issue, which only means it's going to be like beyond November when she has made her ruling. We should start doing a counter. She's holding this trial hostage. And the amount of days that it's taken her without having set a trial date, it should be like 0 dark 30. We should be writing on with a board like 227 days and no trial set.
It's a great point. The reason that she's doing this is she sets the hearing in November. She asks for supplemental briefing. That takes us into 2025. She asks for more supplemental briefing. I think in her own mind, she's going to try to do everything she can. If she was left to her own without special counsel Jack Smith being able to appeal anything, she'd drag this out till 2030, till as long as possible. But anyway, but the question is can special counsel Jack Smith appeal to the 11th Circuit on this issue of modification of the conditions of Donald Trump's release, which is an appealable order should Judge Cannon make the order. Judge Cannon has not yet made the order. She's ordered supplemental briefing as part of her plan.
We like to show comparisons. Karen had a great one, and I joined her on Wednesday. Just so we show that we're not being unfair to her to critiquing Aileen Cannon. Menendez in my home state of New York, a senator who took apparently gold bricks as bribes in an elaborate government contracting public corruption scheme involving halal certification for food going over to the overseas for our armed forces. That he's already at trial. That already went to trial, is going to trial within 7 months of the indictment. Hunter Biden is going to trial twice within a year of his indictments. So yes, there are some civil cases, for instance, that Ben, you and I work on. They'll go on 2, 3, 5, 7, 8 years, no doubt. But criminal cases, they're a year and a half tops. Welcome back. It's a little podcast we like to call Legal AF, and now you know why. We do it on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on the MeidasTouch Network. Help them get to 3 million free subscribers. We're building this network with our bare hands, with your help. No outside investors. Nobody censors what we say. We're unplugged. We're unfiltered, occasionally unhinged about the intersection of law and politics. And then you can pick us up wherever you get your audio podcast from. Wednesdays, I do the show with Karen Friedman at Nifolo. Saturdays with Ben Meiselas. And then we do hot takes like this one about every hour at the intersection of law and politics with lawyers talking about things. They know what they're talking about, which is so refreshing these days. So if you know all about Legal AF, you're already part of our audience. We can't thank you enough. Take that clip, a little mini Legal AF, send it off to people in your life and ask them to become part of our audience as we continue to build towards 3 million free subscribers. If you don't know what I'm talking about, who is this guy in these glasses? I'm Michael Popok. That was Legal AF. And we invite you to try us on Wednesdays and Saturdays at 8 p.m. Eastern Time and on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.